inquiries again has to be made in respect to other survivors who might not kind of neatly fit this criteria. And when we're looking at the homelessness application, basically initially you should focus on the first 3 points, and obviously showing someone if presents, you have to kind of assess if they're homeless. However, that does not have to be only street homeless. It could be sofa surfing, and as well, if the accommodation was provided or is linked to the trafficker, then it's not safe for them to stay in that accommodation. Therefore, at that point, they are definitely homeless. Eligibility, I will touch in a minute, and as well, priority need, kind of, you've got a few examples of priority need, but as well, being a victim, a potential victim and survivor of modern slavery should kind of fit into priority need. And again, Modern Slavery Act and then the guidance to it basically mentions again about that local authority have to consider the circumstances of a potential victim and therefore assess, their current accommodation and if it's suitable for them to remain where they are. And coming back to eligibility, it's quite often the question is, can a person who was exploited could be treated as worker, retained worker, could have a status and therefore be eligible for assistance through the homelessness provision? And the answer is yes. It's not only a person who is a British or who has already certain leave to remain, but as well a person who is, for example, EA national, and was exploited sometimes for years, sometimes even over 5 years, which would then lead to them having permanent residency, which then entitles that person to welfare assistance and support. And, the assessment has to be if the work was real, genuine, or if they were paid and kind of, but prevention of, obviously with not having evidence of that work should not prevent the person to be supported. And there is, we obviously might not have evidence of their pay slips and kind of contract, but with the account, with the person's account, you will hear that maybe they've worked 40 hours a week and they've been paid minimum wage. However, it's not their fault that the money were taken from them, and they couldn't, obviously, they cannot now show you the evidence of that. And running through as well, like various appeals at the tribunals, we can as well, we've got a lot of decisions from judges who are accepting that obviously exploitative work is a genuine work and therefore should be accepted when assessing persons' eligibility for benefits or wider support. And again, the Housing and Homelessness Code of Guidance refers to section 1 and 8. And what is as well important, 1 and 9, sorry. And what is important here as well, whenever you're assessing a person, housing authorities should take into account advice from specialist agencies, and that should help you to assess as well the eligibility for the support, because those agencies might then have quite a lot of information that will be helpful and for you to kind of make your inquiries. They might be able to answer a lot of your questions. So if you receive a letter, if you receive, someone comes, as support worker or whoever comes with that person, then from an agency, then please try to kind of take that account, and that will as well help to kind of prevent the survivor again to tell their story and possibly be re-traumatized. And and back to Becky.
Thanks, Lisa. So one of the things we wanted to touch on, some sort of issues that seem to be confusing, I think, because of the fact that it's just not really clear around, but I think lots of advice or sort of inquiries that they get, or what about if somebody hasn't yet got a positive reasonable grounds decision? Are they able to get accommodation? So the guidance helpfully actually sets out some guidance on this, and the answer actually is yes, that on certain facts and in certain cases somebody can still access that right to safe and secure accommodation before they've received their positive reasonable grounds decision. So here we've referred to the statutory guidance, Annex F 15.2. If housing authorities believe an individual with recourse to public funds, so effectively this is somebody that would be eligible for assistance under the Housing Act, would be homeless as a result of being a victim on slavery, safe accommodation should be provided between referral to the NRM and a reasonable grounds decision. So you don't have to wait as a local authority until the RG decision comes through before you can provide that safe and secure accommodation. In fact, actually, you should provide it earlier if that person's going to be homeless in a position of danger, and you have a legal obligation to do that, because you've also got a prevention obligation as well as an obligation to provide safe and secure accommodation. So this is also touched on in Chapter 25 of the Homelessness Code of Guidance. 25.18, if housing authorities believe an individual may be vulnerable as a result of being a victim on slavery following referral to the NRM, they should ensure that accommodation is available while they are waiting for an initial reasonable grounds decision. So that is something that we see sometimes. There seems to be an issue of getting housing in place before the RG when somebody actually has a need for that, and they're at risk if they will not have that. If we could go to the next slide, please, Eliza. So this is the basis for law in that the protective duty under Article 4 arises before the competent authority makes its decision. So Article 4 can be triggered when somebody has recognised that this person could be a potential victim of trafficking and they've got a risk. So this was in the case of our TDT and the Secretary of State for the Home Department. And we'll move on to the next slide, because the guidance also talks about the most important thing being ensuring immediate safety. 5.3, this is the Modern Slavery Act guidance. The safety, protection, and support of the potential victim must always be the first priority. Victims of modern slavery are a vulnerable group, etc., etc. So I guess what does this look like in practice? It means if you've got somebody that's shown up at a local authority, and they're presenting to a housing officer, and the housing officer is like, right, this person's got, indicators that they could be a victim of trafficking. You've sort of got two things in play here. You've obviously got the identification duty, and which the local authority can discharge or should discharge by being the first responder and referring this person into the NRM if that is what they would like to do, if they provide consent for that, or their duty to notify if they do not provide consent. But they've also got the duty to provide that safe and secure accommodation. So in practice, it may look like, that person needs to be put in a safe accommodation space before you are able to process the NRM referral effectively, because obviously that might take some time to make sure that that referral is proper, the person has had the advice they need about whether they want to go into the NRM. You're actually putting in an effective NRM referral. So it's important to look at these things holistically. And I guess this also brings in the tension that we get a lot of questions about is, so when should somebody go to a safe house and when should somebody go to the local authority? And if they need accommodation right now, is the local authority supposed to provide that, or is the safe house supposed to provide that? And I'm afraid it seems like a cop-out answer, but it's going to come down to the facts of the case as to whether that person should be in the safe house or whether the local authority have got the responsibility. The important thing that should not happen, that I think is happening far too often, is that people are stuck in between these two bodies, with perhaps the victim care contract saying, provider saying, and Home Office saying, not a problem, they're eligible for local authority support. The local authority saying, we don't think they're eligible, they should go into a safe house. So this person is ping-ponged between the two. And that means that there is a failing of the state here to discharge the duties. And in my view, potentially both the local authority and the Home Office could be liable to litigation there. So it's important not to just say, not my problem. What does the guidance say about this? So 15.4, emergency accommodation is still available under the victim care contract where potential victims are ineligible for other housing or that housing is unsafe or unsuitable. So here you've got some really helpful guidance. If you've got, the local authority has got a duty to accommodate, but the accommodation that the local authority is providing is not going to be suitable on the individual facts of that case, that doesn't mean that the person has no chance of going into the victim care contract to get safe house accommodation. That may be appropriate, that they do need to be in a safe house instead. 15.5 echoes the same thing. It talks about how if there's a potential victim and they're not eligible for local authority support, or where local authority support is not suitable, then the victim care contract could provide that accommodation for them. And 15.6 also talks about how, again, emergency accommodation will also be provided under the victim care contract for potential victims where there's reason to believe other accommodation available to them may be unsafe or unsuitable. And I think I just want to sort of cast our mind back again to when we were talking about international obligations at the start, albeit very quickly, I'm sorry, very limited time and a lot of content, but it talked about accommodation needing to be safe and appropriate. And so that's why we come back to looking at individual facts of the case. What is appropriate for this person? So moving on, because there's helpfully again more commentary on this point in the statutory guidance, which is why it's so important, I think, especially to be reading Annex F and looking at that when you're making homelessness decisions and when you're also looking at allocating accommodation for victims of trafficking. So when a potential victim is already in appropriate accommodation, such as local authority accommodation, asylum accommodation, or other safe and secure accommodation, and there is no risk to them to remain in that accommodation, they will usually continue to remain there. So I do add this because I think the reality is that there's two sides to this. I think, and I just want to be careful, I think, in also managing victims of trafficking expectations, because the reality is that the state may have already discharged that obligation, and if it's found on the facts that their current accommodation is suitable, then actually they may not be able to get a safe housing spot, even if that's what they want. So it isn't a sort of a free-for-all either, and it's sort of a balancing act of making sure the person is informed or realistically informed, but their actual needs have been looked at. And 15.9, and I think this is very important, the views of the victim and the needs-based assessment will be taken into account when determining whether or not the person should go into the victim care contract accommodation. So the views of the victim, I think we need to be making sure that both, whether it's the housing officer, whether it's the NRM support worker, and I think both should be feeding into this needs-based assessment that the Salvation Army will undertake to see whether this person should be moved from the local authority accommodation to the victim care contract accommodation. Actually, what does that person want? And I know I talked about balancing expectations, but it's also there's a subjective element to this. If that person, if that victim feels scared in the area because of their trafficking experiences, then that should be put forward. Perhaps the relevant support worker might disagree, but at the same time, those views need to be put forward because that's how the victim feels, and it's important that they're able to access the appropriate accommodation based on their specific needs. And also, I've highlighted this at the end here, is just to make sure that this informed consent thing actually is informed consent. A victim needs to understand the implications of these decisions as well, because the reality is if somebody, say, has been identified in one local authority area, but it's determined that it's appropriate for them to go to a safe house because that local authority, the accommodation they would provide would not be suitable, then they may end up going to a safe house, well out of area, and they may be in that safe house for a very long period of time, which means, down the track, they actually might not have a local connection to that local authority that initially identified them. So they may not be able to get local authority accommodation in that area in the future. So it's sort of just talking through actually the consequences of these decisions for somebody and making sure it is an informed decision for them. If we can move on, please, Eliza. Thank you. And lastly, I just sort of wanted to, when we're touching on this, I wanted to add this in, that the guidance sets out at 15.10, this is still Annex F, support providers shall keep the potential victim or victim's accommodation needs under review throughout the time the victim care contract support. And if somebody is in local authority accommodation, they can still be within victim care contract support at the same time, because they could be receiving outreach support through the NRM and subsistence support, and so that support can coexist. But it's important to think this is not like a one-size-fits-all. Back in 2016, we made this assessment, and these were the needs. So now, done and dusted. Absolutely not. I think it's important to keep alive to what's going on in the case, and it may be that that person's accommodation needs change over the course of their time during the identification process. If we can move on, please, Eliza. Thank you. Okay, so this is a bit of a bugbear for me, and something I talk about a lot, but someone's already mentioned it, and I think perhaps it's a frustration that many share within the sector, and how often, because of the limitations around information sharing, it seems to be very hard to work together. You refer somebody into the NRM and then you never know where they've gone or hear about that person again. Actually, within this wider international framework that we've talked about, there is a positive obligation, in fact, a duty on the state for the various bodies to be coordinating and working together. And actually, so it's not just a best practice thing. There's actually a legal duty here to cooperate and coordinate between relevant organisations that are providing assistance to victims. And I just kind of want to put this forward, but I feel that perhaps sometimes the restrictions around GDPR can be used perhaps to the extreme where we're saying, oh, we can't work together because of GDPR. They're not mutually exclusive. You can discharge your duty to cooperate and coordinate and discharge your information duties and obligations under GDPR at the same time. So I think we just need to be aware that, perhaps by not talking with others and obviously with the proper consent and the protections in place, you could be liable for not cooperating and coordinating. And some of the challenges that I have run have included a judicial review challenge where the local authority, in some cases, and the Home Office in other cases, have been the defendant. And I've actually, you know, one of my grounds of challenge has been a breach for failing to cooperate and coordinate when it comes to discharging your obligations to support this person. So it's really important to remember that, and I think this is where there's a room for great improvement within the sector. Moving on, please, Eliza. I think we wanted to talk about some case examples now, because I know we talked about a lot of theory. Eliza, do you want to go first, or do you want me to kick off with this case?
I think you had a really good example which basically ran through everything. I'll just maybe quickly mention a few that I've, maybe one good one and one maybe not so good one. One is basically as well, quite often we're probably not going to have time to mention Local Aims Act, but I just wanted to kind of show an example where Local Aims Act, using that, is quite important. And it's just basically an example where a client was already post NRM and had positive CG, but for whatever reason, the support that was put in place after that has unfortunately fell through, and the person was so desperate that he went back to his trafficker. At that point, he contacted us, and we have referred to a local authority, to the housing. However, it was refused on eligibility, but the team decided to refer to another team within local authority and assess, do they have some kind of duty or power to use it? And they use Local Aims Act, which says, you know, gives the power to local authority to do whatever it's needed to be done, and basically was assessed to prevent breach of this person's human rights. That person was accommodated, was provided with subsistence, and even safeguarded, and was moved to a different city, so to a different local authority, because that seemed like a right thing to do. And later on, the eligibility, the status was established, and obviously he moved to be supported through the other mainstream kind of support mechanism. I don't know, Becky, if you want to mention maybe quickly your example, or are we just totally out of time?
Yeah, I'll quickly do it, because I hope it will be helpful, I guess, if local authorities are thinking about potential legal liability around modern slavery. But I also just want to comment, as much as the example I'm giving is bad practice and was a breach of legal duties, there has been some local authorities that have been excellent, and I don't want this to seem to be just like an attack. I know there are individuals that, you know, go above and beyond in their roles, and for that, like, I'm really grateful, and I'm sure many survivors are grateful. So there is some really great practice out there. But in this case, there was just multiple breaches. So we had it was a client of ATLEU that came to ATLEU because they were at risk of destitution. That seemed to be the initial issue when the pandemic sort of hit. And it turned out that they'd lost their job in March 2020, and their employment was connected to their accommodation provider. So the person that they were paying rent to was out of the wages that they were also being paid by the same person. So already sort of, I'm sure many of you will be the same, okay, ears pricking up, this seems like this could be, you know, potentially an exploitative relationship. It turns out it was. Once we did some more digging into the facts of this case, it was apparent that this person was a victim of forced labour and labour exploitation. They'd been recruited into this role, and there had been, you know, use of deceptive leads and abuse of vulnerability, where the elements were made out for this to be a case of modern slavery. And but because of the pandemic, the work had dried up, and so the trafficker, the potential trafficker, didn't want to house this person anymore, so they just were going to be made to be destitute, the potential victim. Which I actually think, I wouldn't be surprised if that happened, you know, a lot across the UK at that time. Suddenly, people that were in exploitative work, traffickers had no use for them anymore. They couldn't put them to work because of the pandemic, and so people were left in a position of homelessness and destitution, like our client. And so we assisted him to present at the local authority, and we asked the local authority to act as both first responder and also to provide safe and secure accommodation through Section 108 and Section 184 of the Housing Act, because it was our client was an EA national, and we believed he was eligible as he had a retained worker status from working in exploitative work. He also had permanent resident status from being a worker in the UK for over 5 years. And from the get-go, the team...
Sorry, we're running so late. Could you quickly wrap up this example? I'm so sorry, it's fascinating, but we're running very late. So if you could just quickly wrap that up, and then we'll move to the next speaker. Thanks.
No problem at all. Sorry, Tamara. So basically, the local authority, the homelessness team, didn't know what a first responder was. They didn't know what the role was. And in order to get that accommodation in place, we had to send a pre-action letter threatening judicial review to trigger the Section 108 duty, which is a very low threshold. So that was required, and then accommodation was provided. We also had to send legal representations to ensure that the local authority did act as first responder, and that nearly resulted in a judicial review challenge in itself for failing to identify and effect that referral. And then later on, the accommodation that the local authority provided was so close to where the trafficking had taken place that we then had to start a suitability challenge to say that this accommodation that you provided is not suitable. And in the end, our client got moved to a safe house after the support worker asked Salvation Army to transfer them. But in the end, we had to pre-action both the Home Office and the local authority to make that take place. We said there's a failure to work together here. There's a failure to discharge the duty to provide safe and secure accommodation. And in this case, this person, even though they're eligible for local authority accommodation, they should be in a safe house. But I just want to be clear there that on those facts, they did end up in a safe house. But in other facts, maybe the local authority should have been the person to still transfer the person to another borough. So I'd encourage people to approach this like a domestic violence case. And perhaps, as we see quite often in cases of domestic violence, people are transferred between boroughs to make sure they're in safe and appropriate accommodation. Thanks, Tamara. Sorry to have so much content in so little time.
Just going to change the agenda a little bit because we are running very over, and our speaker Laura Duran has to leave. So we're going to now hear. Before, we're going to first hear, if that's all right, the local authorities' duties in delivering appropriate support for children by Laura Duran from ECPAT UK.
Thanks so much for that, Tamara. Can everybody see me?
Yes. If I can ask all speakers to keep an eye out on my, because I will be showing signs when you've got 1 minute left, and I think people, when they've got slides, aren't able to see that, but do try and keep an eye on the time, all speakers going forward. Thanks.
Will do, thank you. I'm trying to share my PowerPoint presentation, but I don't think it's letting me. Rachel, I don't know if you were able to share it. So I'll get started just in the interest of time whilst the PowerPoint presentation is being sorted out. So hello everybody, it's so great to be here with all of you, and thank you so much for joining. My name is Laura and I'm a policy officer for an organization called ECPAT UK. ECPAT is a very small charity, but we've been around for quite a long time, and we predominantly work on issues affecting children and exploitation. So we published the first piece of research around child trafficking many years ago, and we have led a lot of campaigns around the issues affecting child victims of trafficking, as well as other issues that we work with in regards to the exploitation of children. We're part of the ECPAT International Network, which has representation in almost every country around the world. And we work very closely with a lot of our partners in different countries to ensure that children are protected everywhere. Oh, great. So here's the presentation. So what I'm going to be focusing on today is the specific duties owed to child victims of trafficking from local authorities. Specifically, I'm going to be focusing around the duties arising from the recently published statutory guidance on the Modern Slavery Act. So if you could flip the slide over. Rachel, thank you so much. Right, so obviously, oh no, one back. Ooh, if you could go one slide backwards, thanks. So obviously you will all be aware that the principal duties owed to children obviously do not come from the Modern Slavery Act. They are the statutory duties that local authorities hold under originally the Children's Act of 1989, but the subsequent Children's Act and the Children and Social Work Act of 2017. Obviously, what underpins all practice related to child victims of trafficking will be as well the guidance, the statutory guidance, working together to safeguard children, as well as children who run away or go missing from home or care. So the entirety of my discussion today will be underpinned by the principle that the main priority is always to keep a child safe. And I want to remind all participants that the support owed to children is not contingent to entering the NRM. Another principal duty that arises from the Modern Slavery Act, which hasn't come into force at the moment, is the duty that must be given to independent child trafficking guardians. I believe you're going to be hearing from the ICTUGs in Croydon later on in the afternoon. But this is something really important to keep in mind with regards to your duties within the local authority. Unfortunately, the independent child trafficking guardians are not yet available in all areas in England and Wales. They're only available currently in 1/3 of local authorities, but at some point in time, there will likely be guardians in your area, and once this section of the Modern Slavery Act comes into force, it will be a statutory duty to pay due regard to independent child trafficking guardians' views. At the moment, this duty is set out in the interim guidance, but it's not yet in place due to the fact that we don't yet have regulations underpinning this provision of the legislation. If you could change the slide, Rachel, that would be fantastic. Thank you. So I wanted to focus first on the immediate duties we need to be mindful of. I think other speakers later on in the afternoon are going to be discussing best practice around the care and support for child victims of trafficking, but I wanted to state what is actually a baseline duty. So when a child becomes known to a local authority and there's any suspicion that the child might be exploited, children's social care should decide that within 24-hour period whether to undertake an initial assessment and determine whether this child is a child in need. Obviously, all of you in the call who some of you might work for a local authority, but these are specific duties set out in the Children's Act that pertain to children's social care. So when we talk about a child in need, we're talking about determining whether this child is owed duties under Section 17 of the Act. What I'm talking about here is also set out in the Modern Slavery Guidance, which links to those responsibilities for children's social care to the duties owed to children. And the reason why these immediate duties are so important is because we all have to be mindful about the significant risk of harm that potential child victims of trafficking may be facing, and to make sure that children's social care acts appropriately within their immediate duties in order to safeguard children from further harm, such as going missing or being re-trafficked. This is why this initial assessment should include an assessment of risk and safety planning. This is absolutely essential, and within the context of this risk assessment and safety planning, it is key that those in children's social care that are undertaking these duties have the training necessary to ensure that they understand the actual risks facing children. It's a bit of a pointless exercise if we assess risk, but those who are making the assessment don't really have the training in order to make those determinations with the full knowledge needed to really appreciate the risk of harm that a child is facing. Following these considerations around risk and safety, the statutory guidance sets out that a strategy discussion should be convened. Obviously, this is in line with the working together guidance. Under that strategy discussion, there's quite a few things that need to be considered. Whether or not to initiate a Section 47 inquiry should be discussed within that strategy discussion, as well as if the child is in need of accommodation should be set out, if those duties need to be discharged under Section 20. I think that at this point in time within the strategy discussion, one of the biggest failings we see around many cases of potential child victims of trafficking is the lack of consideration around the wider context and the extrafamilial harms that children are facing. So it's very important, as I said before, that social workers who are trained in the specific issues of facing potential child victims of trafficking are taken into account. If this first contact comes from the local police force, it's also important to keep in mind the immediate duties that are extended to local police forces. I think most of us who have been working with children and young people who are potential victims of exploitation have come across many cases where unfortunately their responses, the immediate responses, may include, for example, arrest when a child is, say, found in a place of exploitation such as a cannabis farm, or for example a trap house, or in a place where it's obviously a drug distribution and supply location. I think I want to remind everybody, particularly those in children's social care, that when you're working with your police colleagues, and if we have any police colleagues on the line, that we also remind them of their duties, in that if they suspect that a child is at risk of significant harm, such as that suspicion may arise if, for example, a child is coming to the attention of the local police force, being found at a place of exploitation, they can be taken into immediate police protection under Section 46 of the Children's Act, and it's not always it's not necessary to arrest a child if the arrest is done with the view of keeping the child safe. The statutory guidance also sets out that under this context, appropriate specialist public protection unit within the police should be notified of this action as soon as possible. So this is particularly relevant in cases where the exploitation involves sexual exploitation or other sexual offenses against a child. Then a specialist in the sexual offenses and domestic abuse investigation team must be deployed at the earliest of opportunities. So this is something really key to also keep in mind within those immediate responses to children. Could you flip the slide now, Rachel? I'm gonna run through these now because I'm running out of time. But if we can set out now the long-term duties, as you've heard through the day, local authorities are first responders. So this is a long-term duty for local authorities. Within the context of children's social care, we need to keep in mind that there's a statutory duty to notify the Home Office when they come across a potential victim of modern slavery. In the context of children, this is discharged when referring a child into the NRM. Who makes that NRM referral is not an immediate duty. This is a duty that can be considered within the context of that strategy meeting to determine who is the most appropriate person to fulfill that duty within the first responder team that will be meeting in order to discuss the strategy taken forth to protect this child. Councils also have to ensure that all individuals acting as first responders have that adequate training. This is a duty also set out in the guidance, as well as ensuring that whenever there's deployment of teams within the council to disrupt modern slavery, such as regulatory or community safety services, that these joint actions be coordinated and that training be provided, especially if those disruption activities are likely to come across child victims. It's essential that those activities include the input and participation of children's social care teams. If you could move the slide now, Rachel, please.
Laura, if you can just wrap up quickly, that'd be great, just because we're running a bit behind. Thanks.
Yes, this is the last bit. So I'm gonna leave you now with the final food for thought. I have set out in my presentation, obviously, the additional duties owed to children who are assessed as being children in need, as regulated. Everybody working in children's social care will be very familiar to these. But these regulations, such as the care planning, placement, and care review, and the regulations around care leavers, set out the responsibilities to provide for children long-term with regards to their education, mental health, accommodation provisions. So these are important to keep in mind. You can also access further guidance, which is a bit old and dated now, unfortunately. This is practice guidance that was produced in 2011. In the Safeguarding Children Who May Have Been Trafficked. And we also have statutory guidance that sets out the duties to unaccompanied migrant children and child victims of modern slavery who are foreign national children. So that piece of guidance will contain key to ensure that the support and care for those children is appropriate. If you have any further questions for us, you can always reach out. Our contact details are in their presentation. I'm sorry this was such a rush through, but do reach out to us if you have any questions. And thank you so much for having me here today.
Thank you so much, Laura. I'm so sorry. I mean, your talk and Rebecca's and Eliza's was so fascinating. We've got such great feedback on the chat saying how brilliant they are. So I'm really sorry I've had to rush people, but we just have got to keep to time. So speakers, if they aren't able to see my signs, speakers, can you please just set a kind of a stopwatch so you can see your times when you're speaking? That'd be great. We're going to move on. Having heard the local authority duties both for adults and children, we're now going to hear from Rachel Witkin from the Helen Bamber Foundation, who's going to be looking at how to ensure protection, prevention, care and support needs are met by local authorities for adult victims of trafficking.
Thank you very much. I'm just going to pull up my presentation. Okay, can you see that, Tamara?
Yes.
Hello?
Yeah.
Can you see the presentation?
Yep.
Yeah, okay. Well, thank you. First of all, I just wanted to say that listening to these presentations shows me that I need to learn loads, and I would love to have a longer day listening to everybody because there is so much knowledge and it's so interesting to hear. I'm also aware that there are some very key people from the local authorities across the board here, and so they'll be watching this thinking about how to escalate and disseminate really good practice everywhere else, because I'm sure they are, you know, keying into all of these different presentations. So I'm going to start by just talking a little bit about from the point of view of the Helen Bamber Foundation, which works with victims of and survivors of modern slavery who are in and outside of the NRM system, are mainly in the asylum system as well. We work with them for a period of about 5 years in our counter-trafficking program, and the reason for that would be because that's how long all of this takes, and that's all the different legal systems and situations that they're in, seeing them through in terms of their legal work, their housing and welfare, their trauma and therapy, their health needs, all the whole gamut. So we get a very long distance view of what it looks like for people months and years after coming out of trafficking and slavery. So what I thought it would be useful to do would be to just pick up on a few things in the statutory guidance, working with vulnerable people, which is at Annex D. indicators of modern slavery, including physical and psychological indicators, health indicators, which are very good actually on rereading them, understanding trauma, vulnerability and taking care not to re-traumatize, as mentioned at 6.2. And I think that's interesting because a lot of people who aren't clinicians, including myself, would think, well, hang on, what's that about? How do we do that? Support, which is available under the victim care contract, is so essential, and it's so important that we make relationships with the people who are working in that system and the CQC that's inspecting that system. And also just touching on housing, which is available to victims of modern slavery, which is in section 15. The thing that we've learned over time working between all of these different professions, as we do in a multidisciplinary environment, is that effective communications, as in communications that work, have to meet the specific impact of modern slavery, and they have to do it very quickly, because a lot of us are working in situations where we don't have a lot of time to build relationships, but we need to get to the nub of needs and risks quickly and safely with survivors. And we need, but to do that, we need to understand that while victims of modern slavery are specifically vulnerable, they are also very vulnerable specifically because of the crime of trafficking and slavery, which distorts and destroys all the norms and connections in normal human relationships. Victims have become habituated to concealing or denying mental and physical conditions and injuries and details of their trafficking in order to survive, and also to manage a life in exploitation. So they're not going to tell us, basically, and we're going to need the skills to find things out. This results in a loss of trust generally, not knowing who they can trust, and also, unfortunately, overtrust, which tends to go to perpetrators who are grooming people in a way that targets them because they're specifically vulnerable. And as we all know, people who've been trafficked before are very vulnerable to being picked on by new traffickers who will then perpetrate crimes further upon them. So the fear of others for any survivor that you're working with, and at the Helen Bamber Foundation, we work with adults, I should mention that, but we also work with children who are with adults, but we're not a child service. And I know that Love 146 and others are going to be talking about children very specifically, but survivors must know who is in the room with them at all times and what their role is. We all need to know this because interpreters need to be vetted and qualified, and they need to know how to work with survivors and not to cause any risk or danger. So a really good interpreter is going to work with you in understanding that and understand the need for a lot of introduction and reassurance. Professional responses to modern survivors of modern slavery must be reassuring, sensitive, authentic, and restorative within remit, because you're going to have to make that immediate message to survivors that your situation with them is different to the one that they're used to with traffickers. Following a trauma-informed code of conduct, which is something we've published on our website, can help professionals to remain safe and well in the course of this work, avoiding themselves secondary traumatization and professional burnout, because a lot of people are pulling on their own compassion and kindness in order to work with survivors, and that's a bit of a problem when it comes to the effect on themselves. So having actually a code to follow can be helpful. So there isn't time to talk about the trauma-informed code of conduct much, except to flag it up and say that it's very simple to use. So it shows people how to use trauma-informed environments and how you can make a trauma-informed environment from literally any space that you're working with, even a tiny space. It's written with a clinical psychologist who works in conflict zones as well as in offices and clinics. So it's basically very informative about how you can use a code of practice anywhere. So understanding survivors' presentation, how to check pace, movement, gesture, eye contact, open expression and listening, how to make sure that you have introductions, clarity, explanation, and how to framework those very difficult questions and information which regard extremely traumatic events in the life of the person or in their family. How to create the illusion of time for the person that you're working with, which is immensely helpful, I find, in keeping distress down. And it's just something that that's really helpful to remember when you're working with people who are traumatized. Referring back to the here and now when you're presented with a situation where somebody is becoming overwhelmed from traumatic histories and future fears and uncertainties. The only place that somebody can feel confident again is right here in the here and now. So there are some techniques to do that, and they can really help people to stop being overwhelmed with distress. Getting to the issues of safety and risk quickly, effectively and simply is about asking simple questions that translate easily, both into different languages, but also just in the general meaning, rather than using complex terms or expecting people to identify themselves as having been trafficked or enslaved. Working with survivors to find out the best methods of asking them questions. There is no one size fits all. And as I said, it's very useful to framework difficult questions and to make sure that survivors are not worried about suddenly having symptoms, intrusive symptoms come up, that they feel confident because of the way that you're working with them. Enabling disclosure, how to work with chronological memory and not against it, which is a big issue when we come to having all of these cases that go on and on through the legal system, and then the reality of the case comes out, and then they are chastised and penalised for not having said all this in the first place. Often that's to do with the way that they're being worked with and how much opportunity they've had to feel confident in recounting their very difficult story. Bridging access to other trusted professionals and services is really important to build a multidisciplinary team around each survivor in the right way, and make sure that survivors who have come out of a very traumatic situation are not simply signposted and expected to find it themselves. It also talks about communications which are not helpful or effective and therefore can put survivors at risk. So hopefully that's something that's very simple for all professionals to follow, and when they hear the phrase trauma-informed, they don't feel that they've got to be a therapist or a clinician, or that it doesn't actually belong to them. It's a way of being kind, because it's not. It's actually a way of being effective in every task that you do, whether you're a policeman or woman, whether you're an NGO worker, whether you're a social worker or a lawyer. Oh, sorry, I've got a little animation there, which is which is all about creating the illusion of time and pretending that you have time, which calms everybody down even when they're in a rush. Okay, so I wanted to raise this because it's very important, I think, that we work a lot with people who are in terrible housing. In fact, it's the common issue in London and across the board. And this is a huge trafficking risk. And what I wanted to say was that the Slavery and Trafficking Survivor Care Standards, which were published in 2018, again by the Human Trafficking Foundation, are really useful. And it's important that using communications that are the right ones, we find out about what is needed in housing, what are the risks and needs in housing, and what are the risks and needs with financial care, welfare and support, because a lot of people feel that, well, that's just idealistic, we can't possibly match that, so we're not even going to find out. And that's really not where you want to be. So with authorities and councils, it's important that they at least know what the dangers are with housing and what is needed for survivors in order to work well, even though they struggle with what they can give and what they can do. One of the worst responses to survivors is, and I'm afraid we see this in homeless teams, although obviously it doesn't reflect all homeless teams, is that attitude of, well, wouldn't we all love to have a house in London, and wouldn't we all love to, have all of these needs met? But we're dealing in a situation where women and children are living in gender mixed accommodation. There's a lot of violence around and in asylum properties and NAS housing. There is detention, imprisonment is an actual trafficking risk. And so everybody needs to know about the non-punishment statutory defence. Destitution, street homelessness and relying on others for shelter has just been made even more dangerous by the proposed immigration rules. I'm hoping that isn't going to happen, but Helen Bamber Foundation is part of the detention task force and will be very strong on that issue. High crime, prostitution, drug use, antisocial behaviour areas which have a lack of equal access to law enforcement, where people are phoning the police and the police don't really engage in that area, that is a risk. So if people are coming with these issues, they're probably not going to mention it, but it's really important to keep an eye on housing risks and how those can deteriorate and get into really bad situations for people. And it's equally important to see the green one on the right, which shows you what's actually needed, what's helpful, and how social inclusion is the real key to people keeping safe. And so I am now going to finally say, if you're interested in any of this, please just, you're welcome to find the Trauma Informed Code of Conduct for All Professionals, which is at helenbamber.org. The UK Slavery and Trafficking Survivor Care Standards doesn't date. It's really current. It's really important to get to grips with that. And that's a whole collegiate book written by some really, really good people on how to work with survivors. And then there's also the training framework, identification, care and support of victims and survivors of modern slavery and human trafficking, which has multidisciplinary 3-tiered training if anyone is interested in disseminating that out to councils and authorities. So thank you very much for listening, and thanks for this conference. It's been fantastic so far.
Thank you, Rachel. That was brilliant. Just for delegates, if you look within the chat, you'll find a link that Rachel's put there for the Trauma Informed Code of Conduct. I'll just mention the survivor care standards. This isn't about spending lots of money. This is just about ensuring that all the agencies involved have a consistent approach, which just gives victims and survivors that added degree of feeling safe, because everyone's sort of coming at it from the same direction. So I apologise. We're going to move on rather than take questions just because of timing. I just want to give the other speakers the opportunity to provide input, because they will be really interesting. So for this, the last section, we've got 4 speakers. You'll hear from Space in relation to getting the right support, and this is why support is so important in terms of modern slavery. It does need to be bespoke. We'll hear from Love 146. We'll hear from Debbie from Africa in terms of diaspora communities and how it is so important that we engage with those communities to properly understand how we can best support them. And finally, from London Borough of Croydon and from Bernardo's in relation to the independent child trafficking guardians. So I will first of all hand over to Space for their presentation.
Hi, thank you very much, Phil. Thank you to everybody for coming back after lunch, if you've had lunch. I'm going to just dive straight in. I don't know whether most of you have heard of Space or not. We are a CCE County Lines specific specialist organisation. We basically campaign, train, and we advocate for British victims, in essence, involved in county lines. Phil, I'm just going to try and see if I can get these slides to come up. If not, I'll have to revert back to you if that's okay.
Yeah, that's no problem. I'm poised and ready, I think.
Okay. Right, let's hope this works. Have I disappeared?
Yeah, I think, yeah. But then we've got Debbie. Debbie's appeared on the screen now. I don't know what's going on.
Oh, hold on. I think mine's just loading. Is it? Right. Let's see how this works. Right. Shall we not bother and just get you to do it if you don't mind?
Yeah, no problem. Just bear with me. Okay.
Okay, great, thank you. So I'm going to speak really fast so that I can try and keep this to time. So that's the introduction for us. Next slide, please, Phil. Okay, so basically, these are the factors that you will come across in a county line stroke child criminal exploitation case. These are very, very relevant and very regular features and factors in county lines, but unfortunately there remains a huge gap in awareness. It's still very, very patchy at best within local authorities, and we're still seeing a lot of the solutions to some of these issues being completely wrongly focused. So just to give you a quick example, lots and lots of children are still being diverted towards a Section 20 or Section 25 placement, when actually this has very little value for county lines exploited children, and actually create and exacerbate harm which just wasn't there prior to the placement. Equally, contextual safeguarding, I know it's a big thing. Carleen Furman doing fantastic work around that, but we're still finding within a lot of local authorities, they've just not heard of it and they don't know what it is. And to give you a very, very quick example, we're seeing lots and lots of parents who are, involved within social care. So the extrafamilial harm is still not being registered or recognised, and they're actually being told to go on parenting courses, which is completely inappropriate and is not a contextual safeguarding response at all. Next one, please. So these are just headers. I'm just going to pick out a few bits in view of the short time here. So indicators of county lines, obviously, sorry, not indicators, grooming. This remains really still very ill understood. Now, grooming is the silent driver behind county lines. It is the silent driver behind a lot of the serious violence that we're seeing as well. And it just is that one factor that is not being talked about. You will not see it in meetings being discussed. You will not see it in reports, official reports, court reports. The word exploitation is not interchangeable with the word grooming. They're two different things. And actually, it starts with the grooming. The coercion and the threats and the reprisals are not the same as the grooming. That these are two separate cohorts and they do overlap, but actually grooming has a massive part to play in county lines. Next one, please. So that's really just to give you a visual picture of what's going on, and this is very much how affected families are seeing what's happening. The child is being groomed and it's completely being missed. The parent is the only one who knows what the child was like pre-county lines, and it's definitely down to the grooming, but actually nobody's hearing it. Next one, please. So indicators remains, again, an issue. They're not being understood, they're not being recognised, and if they are being grasped, they are being misinterpreted. So in the main, county lines are not being spotted. And just to give you a very quick couple of examples, in one case, the child was involved in all sorts of things for a good 18 months prior to any local authority or police being involved. And then when a packet of something was found in the house, it came back after police analysis as paracetamol stroke some other substance such as baking powder. Now, it was clear to everybody that this was a county lines issue, given everything that had been highlighted prior to that finding. Yet the social worker came into that family and said, I've spoken to the child, said to the parents, I've spoken to the child is telling me it's all okay, this was just a prank for school, it's not drugs, and it was just a joke. And the social worker basically said to the parents, there's nothing really to worry about here. Now, another case, parents told us, where they had repeat missing. And for those of you who are aware closely with repeat missing, it is hugely disruptive on the family, aside from all the risk and harm that's involved. And it tends to happen immediately after school all the way into overnight and early hours. Now, the parent in that particular case highlighted to the social worker that it was all creating a lot of havoc, obviously, and there were other members of the family who were really severely disrupted and, needed to eat on time, for example. So, meal times were being disrupted severely because the child wasn't there. And obviously the family is waiting for the child to get home and nobody's eating. And in that particular case, the social worker said to the parent, well, why don't you move your meal times to 10 o'clock? which is at that point in the trajectory, that's when the child was returning home around 10, 11 o'clock. So again, it's just completely missing the point as to what's going on. Also within the indicators, there are lots and lots of signs to show that there is hatred towards parents. Again, this is all down to the grooming, the parents, and of course this is in cases where there was no issue whatsoever between the parent and the child prior to the grooming. And also hatred towards authority. Now, this is primarily police and secondly, local authority staff, including social workers. Now, this hatred is not really understood as to where it's stemming from and why, and actually listening to the voice of the child when you're doing your assessments, you're getting the voice of the groomer, and this is still being missed and has massive consequences in terms of gains for the organised crime group and consequences for the parent. Extrafamilial harm, again, still a massive elephant in the room. Lots and lots of assessments are being done by social workers, and it's completely missing that this is harm beyond the family front door. And the focus is landing on the parent somehow being complicit or at fault. Any indicators where you've got somebody who's, you know, in their mid to late teens is not being actually picked up as indicators of county lines, but being diverted as the child exercising their independence, growing into a teen and having their own mind. So the parent is basically being told that they kind of need to let things go a bit and be less strict and be less controlling, which of course none of these parents are happy to do because they can see what the professionals can't. Next one, please. So I'm just going to leave that up there because it actually speaks volumes about what's going on, but is regularly missed in terms of the indicators. Lots and lots of things happen. The same things are kind of picked up by a lot of people, but they don't understand kind of the meaning behind that behaviour. And actually, a lot of the things you're seeing in these young people are as a result of the fact that they cannot speak and they cannot tell you what the issue is. So all you're left with is little signals, and all of those little signals are exactly about that. They're at serious risk of harm, but they can't tell you. Next one, please. Right, so missing, huge issues around this still. I've just come off a long call with the police on this morning. It's, you know, continuing to have lots and lots of gaps and lack of awareness as to what exactly is going on. But this is still seen as, return home interviews are still very, very patchy in terms of local authorities. They're not necessarily being done, and they're certainly not always being done within the statutory requirement of 72 hours per episode. I would also say don't wait for an escalation. Missing is one of the first triggers of involving local authority and police, but actually the damage has long been done by the time you encounter your first missing episode in one of your cases. The grooming is completely embedded and successful by that time, so it's actually too late for most of the children. But even then, don't wait for further escalation, such as repeat episodes to identify exploitation, etc. What we're seeing regularly is a lack of early intervention, a lack of an NRM referral, because missing is a key indicator of county line involvement, but it's still not going in as an NRM referral, and also early diversion opportunities. All of these things should be happening as standard, but they are extremely rare at best currently. Next one, please. Just going to touch on this to say, although this is a local authority event, the gaps and challenges are spread right across police, health, local authorities, yacht, education, social care placements, criminal justice system, and it's the huge issues around a lot of the responses that are happening. I obviously don't have time to go into that, but really just to make that point. Next one, please. So a very quick snapshot in terms of local authorities. Victims are not meeting thresholds, and so many of them are not on a child in need plan or a child protection plan by the time they contact us, when they should have been, way before in the trajectory. Obviously, the thresholds is a massive issue, especially where you're dealing with parents who don't fit the kind of stereotypical mold, where there's no abuse or neglect or addiction or any of those other things where local authorities tend to be involved. However, exploitation is rife within those families and it's not being acted on. I mentioned Section 20 placements, Section 25 secure orders. They are routinely seen as solutions by local authorities and police to disengage and safeguard young people, but they rarely meet these children's needs, but actually increase the risks. School exclusions and PIUs, I don't think you need me to say any more. If you watched Channel 4 last night, it's all there. Have a look if you haven't. Still, lack of a sort of bespoke CCE interventions. For example, when you're putting these children in secure placements, they're not being given any bespoke interventions for county lines. They're routinely seeing interventions you'd give to CSE victims. What these kids need is ex-gang mentors, for example. They need radicalisation experts. This is rife, but hardly talked about. And they're a captive audience whilst they're there. They're not missing. So, we really need to kind of look at that and look at it as a spend to save opportunity, because the cost of a young person in a placement, for a lot of them, it's £1,000 a day. And then the cost of entering the CJS versus the cost of an ex-gang member mentoring them, and I'm talking about bona fide ex-gang members, because that's a contentious issue in itself. There's minimal or lack of awareness of county lines itself, the NRM. Very, very many families are still coming back to us when we ask them to go back and get their child referred. They're saying the police officer said they've never heard of the NRM, they've never heard of county lines, still today. Lack of recognition of extrafamilial harm, contextual safeguarding, leading to parent blaming. Sorry, when I said police, I meant police and social worker. Reluctance and inability or lack of will to challenge other partners' poor decision making and responses. Again, sadly, this is being reported to us by families all the time, that local authority, social worker will not speak up and say to the police officer, well, actually, that's wrong because we've got evidence of what you're saying is not happening. Parents are regularly citing that the visits that they get are just box ticking. The calls are just because they have to make them within a certain period of time. That social workers and line managers are completely uncontactable, and these are urgent scenarios that they're trying to contact them about, serious violence, etc. And that the constant change of social worker, it's a revolving door, little value really there. And of course, the big thing is there's a huge disconnect between what is being reported by service providers and what the service user is saying, i.e. the family. They do not recognise at all what's going out there officially as what a local authority is doing, because they're saying we are seeing completely the opposite response to what's written there. Next one, please. Very, very quickly. Within county lines, there is a gender bias, and boys are not faring well at all. They're obviously predominantly involved in this type of exploitation. They are seen by the statutory services as having made a lifestyle choice towards criminality, that boys will be boys. They're seen as being drawn to risks, thrills and weapons, that they're seeking out the activity. Not viewed as a victim in the same way as you perhaps would view a female in the same situation. So therefore not seen as vulnerable or in need of protection. And this is playing out horrifically so with so many families. And the perception is that if you're a boy and you come to the attention of statutory services, then it's got to be CCE, county lines, and if you're a girl, it's got to be CSE. And of course the reality isn't that at all. It is boys can be both CCE and CSE, and girls can be both as well. And of course CSE is present in CCE for both genders, and this is something that is overlooked time and time again. Next one, please. We're coming to the end, I promise. So very, very quickly, contextual safeguarding. County lines is predominantly extrafamilial harm. Not all of it, because sadly there are parents who are also complicit. So there is a need to safeguard children in outside spaces and places that they occupy. The harm is not in the home when you're dealing with a protective protective factor, parent and family. And of course, the social work model is set up to recognise and respond to familial abuse in the home, where a normal social work response is going to be A, B or C around that type of abuse. Of course, County Lines doesn't fit in that. It's a round hole square peg scenario, and what's happening, and this has been ongoing for some time, and it's still absolutely the case. Social workers are still missing extrafamilial harm in the main, and that's leading to incorrect judgments and basically County Lines being parked within the original A, B and C assessment. And what that's leading to is a heightened risk for young people, and it's making the parents more frantic because they're not seeing the safeguarding, which is then leading to conflict between social workers and parents, which is then leading to parent blaming. And of course, the only winners are the exploiters and the organised crime groups. I'll just quickly touch on the fact that Space has founded the National Parents as Partners in Exploitation Safeguarding as an advisory group, co-led by NWG and supported by Anne Coffey, now ex-MP. If you go on our website, there's more details around that. Next one, please. This is just one to leave with you to ask yourselves if you're doing this, because this is hugely relevant in extrafamilial harm and County Lines. And this, in essence, is what parents are finding to be the massive problem around statutory response. They're not being heard. The child is being heard, but the child is the voice of the groomer. And when parents are raising red flags and becoming vocal about it, because which parent wouldn't if their child is about to meet death, they're being labelled as over involved in their child's case, dictatorial, controlling, all sorts of labels, and actually all that does is focus on the parent as the problem, whilst the child is just going deeper and deeper into the exploitation. Next one, please. Okay, so modern slavery. I will whiz through this very, very quickly. To put it in context, in 2009, there was 1,161 County Lines referrals into the NRM. Of that, 88% were minors. Now, these will be, almost all will be British kids. In 2020, in the last 3 quarters, that figure was 1,119, and 91% of those were minors. Obviously, that's against the backdrop of COVID, so I'm sure that the figure would be much higher if it was a normal year. Now, we don't view, or certainly we didn't view, British citizens as trafficked or as modern slavery victims. And the ones that we heard about in the media, very rare occurrence, but where we did, they were mainly those with special needs or disability, hence they're being vulnerable to exploitation in the first place. Now, the language of modern slavery didn't really exist at that time as it does now. But what we're seeing still is local authorities are still struggling with their statutory duties or resisting modern slavery within British kids, let alone British adults. This obviously becomes hugely problematic as local authorities are one of 2 statutory first responders, and this inaccurately understood sort of gatekeeping into the NRM is causing huge implications for families. And we know that the modern slavery system is clearly designed for foreign victims in mind, so it follows that its processes and support systems aren't designed to meet the needs of British victims. And I'm going to quickly just cite an analogy that I used for lots and lots of people who contact us that are nothing to do with County Lines, but are CSE victims and survivors who are absolutely frustrated that they're not meeting the response that they should be from that support system. And I explained it to one particular person in a very simple fashion, and I said, your frustration is stemming from the fact that if you were to pretend that you were a blind person, a blind man, walking into a woman's shop to buy clothes, and everybody is super helpful and really, really willing to help you with everything, but actually all the clothes that they're giving you to try on are ladies' clothing, and none of them fit, but nobody's telling you that you're in the wrong shop. And in essence, that is what is happening with British victims who are trapped in the only response there is in terms of trafficking organisations who are actually funded to meet the needs of foreign victims, not British victims. Next one, please. I'm gonna how long have I got?
You're well and truly over.
Oh, okay. Let's skip that one then. Is it not moving?
Don't it should have, I've got referrals and post 18 now on my screen.
Yeah, just skip that, Phil.
Okay.
Just go to the next one. I think suffice to say, huge issues around post 18. We're seeing massive issues with NRM for children that then exacerbates a whole load worse when they hit 18. Next one, please. Children's referrals, all I will say here is, again, there are things that could be completely different here. Parents are basically left out of the loop completely. Obviously, local authorities are the corporate parent for unaccompanied children, but that response is dictating what happens across the board to families, British families with British kids involved in exploitation. They are not involved in the referral. They are not told what the decision is. The letters, when they are sent, are addressed to the minor. The birth parent is not trumping the local authority when they clearly should be, and you know, all these letters should be going to the parent, and actually they're finding that when they ask for these letters from the local authority or the police, the response they're getting is, oh, we don't do that. We might have to go and ask whether that's allowed, and actually that's quite insulting because that child is a minor, and you know, the parent obviously has to be first in line in terms of being you know, told the outcome of a very important thing such as trafficking about their child. And actually there's no requirement to actually tell the child who is going into the NRM from their parents in the background. There's no requirement for the child to know that they're free advocate for the child not to be told for good safeguarding reasons. Next one. Statutory clear-fledged response at 18. You can read that for yourself. You can have every vulnerability under the sun, under 18, you know, groom, send, neurodiverse, mental health, child in need plan, positive NIM, victim of serious violence, and it all drops completely at 18. They're seen to have mental capacity overnight. If they're missing, they're seen as not missing. They're now choosing what they're doing even more because they're an adult and they could say no if they wanted to. And actually the only winners out of that are the organised crime groups, because they're watching exactly what they want, which is the services drop off. There's no recognition that vulnerable child is now a vulnerable adult, and actually the parents are being made to feel completely isolated and viewed as if they're invading that child's privacy if they try and get involved or report that child missing. And of course that's a win-win, and organised crime groups are now starting to move from using minors who will pull out a police officer and a social worker with them, which is not what they want, to over 18s, because no police or social workers are triggered. Next one. We
may need to make this the last slide. I'm just conscious.
Okay, do you want to move that one on? I'll concentrate on the London Boroughs one.
Yeah.
Okay, so just very quickly, that's a snapshot of the NRM referrals in the last quarter, 2020 quarter. And I think it's really important to point out there's three top county lines export areas: London, Birmingham and Liverpool, and this is your London boroughs. And if you can just have a look, the highest is 14 from Newham and the lowest is 1. Now that we all know is not the reality of what's going on, and 25 out of 31 London boroughs had less than 10 or less referrals, and the total adult referrals were only 23, and the total duty to notify, there was 13 from 10 out of 31 boroughs. Now we know almost all adults refuse consent, so how do those figures actually tally up? They just don't. That's not the reality. Can we just have the next slide just to leave up then before we finish, because I won't get time to go into them, but at least people can see what the issue is with British nationals. So I'm going to leave you with that slide, because actually one thing just leads to another, and then it just leads to re-trafficking. But apologies, I've had to rush through a lot of this. If anybody's interested in any more, the details are on our last slide, Phil. Thank you very much for listening.
Thank you very much for that space. That was really interesting. I've seen present a number of times, and I just find it just opens up those difficult discussions that us professionals sometimes struggle to start. So I really appreciate that. I'll just, as I close the slide, I'll invite Lynn from Love 146 to join us, and I will just stop sharing my screen.
Lovely.
We'll see each other. There you go. All yours, Lynn.
Thank you. Hopefully I could share this okay. No. Oh dear. Sorry about this. I'm very sorry. This is.
I'm ready to go if you want me to share my screen.
Is this happening now or not? Let me have a look. Looks like something. Yeah.
Yes. Yeah.
Brilliant. Okay, thank you. Okay, well, good afternoon, everybody. It's been a really interesting webinar, and I just want to thank Rachel and Tamara for inviting me to be part of this. A very quick introduction to myself. I'm a social work background. I've worked with children, young people who've been trafficked for over the past 25 years, and currently I'm the Director of Care for Love 146. So just quickly, Love 146 work with children and young people who've been trafficked into the UK. We work up to and past the age of 25. So we will be around for that young person for as long as it takes. We provide accommodation with our carers for 16 plus. We provide supported independent accommodation for 18 plus care leavers who are survivors of modern day slavery and trafficking. We do outreach work, wraparound support, and we also deliver training as well. Just going to firstly look at what the challenges are within the system and what we see. We know that identification, this is not in all cases, this is in some cases and in some areas. In some areas, I will say there's very good practice, and in some areas there's a way to go, unfortunately. So poor identification, not seen as a victim, sometimes not even seen as a child. So are criminalised and not seen as a victim, could find themselves in detention. Immigration is seen more important than safeguarding. Inappropriate placement, so young people go missing. Research gaps, children are groomed not to tell, and the age assessments as well. So going on to what looks like a good practice system, this is what we work to within Love 146 and with some of the local authorities that we work with as well. As you can see, when a young person is identified as a victim of trafficking, then the immediate safeguarding response is put in place. So appropriate placements are found, so young people don't go missing. So we look at the multi-agency Section 47 investigation. So that will be possibly criminal exploitation against the traffickers, but also then the Section 47 for the child. We look at immediate immediate health needs, and that's including any immediate mental health needs. We then support with the asylum process. And the long-term interventions are around safety work and also looking at any other referrals that need to be made for that young person, including any mental health services as well. This I'm just going to go for a very, very quick sort of case study using, again, the good practice model. So we were informed by the police of a young person being rescued from a cannabis factory. So this was the child protection response. So he was identified as a victim. He was referred to us, and there was a multi-agency Section 47 instigated. He was placed with our carer and he was put on the immediate safety plan. Assessment of risks and immediate health needs was undertaken. We identified the appropriate solicitor for asylum process. We started the safety work. And a part of that also is about building up a trusting relationship with that young person. It's very important to do this quite slowly. So once they're safeguarded, you can actually work on this a bit more slowly and get better results as well. He's still with us, this young person. He actually moved on to our supported independent accommodation. He's in college, he's doing work training. So we've been able to remain that constant for him as well, which has been really, really good for him. Sorry, that was my phone. Looking at the good practice model as well, we think that these are the key knowledge areas for social workers and carers. So we are saying that all carers and social workers need to be trained in these areas, but also IROs as well. I think they're sort of a very important part of that support for a young person. So if you've got an IRO that's not really understanding what the issues are or the risks are around a young person, that can cause problems. So we have that, the carers in the middle. So the carer must be trained in the risk indicators, the safety plan reduction programme. Our social workers or local authority social workers need to have country-specific information, understand legislation, the asylum process, the NRM process, and all working in partnership. So it's a multi-agency response to these young people. Again, just looking at the safeguarding and protection response. So the child is in the middle and it's the multi-agency response around that child. So you're looking at the multi-agency, again, Section 47 investigation. You're looking at the assessment. So is the child at immediate risk of significant harm, trafficking and exploitation? If so, it's the placement, urgent safe accommodations, so carers who understand the trafficking. Address on a need-to-know basis, address flag with the police and the golden hour, immediate safety plan, child protection, investigation to be started. So again, I think it's so important that we realise that this is a multi-agency response. And the sharing of information, I know GDPR and all the rest of it is being used, but we need to be sharing as much as we possibly can with each other. There's a huge issue, I think, for risks around transition for young people. So when a young person becomes 18, their vulnerabilities remain, nothing changes. So survivors who become care leavers should be moved to a supported accommodation that understands the issues for survivors of trafficking moving into adulthood. Understand what the risk indicators might be, look at doing a new risk assessment, new intervention plan. Also, any personal advisors that they're handed on to need to have some understanding or training in child trafficking and understand what those vulnerabilities will be. Outstanding asylum claims is massive, especially if there's a negative decision. The risk of going missing is heightened. So I've been, working with young people, trying to tell them to be patient, that we're going to, look at challenging the decision and really asking these young people not to run. So it's a massive safeguarding issue for these young people. And at a very particular time when the support is reduced. So if our accommodations we just make sure that we do a wraparound support, because we understand that these risk issues come quite quickly when they reach 18. And obviously we've got the emotional and psychological distress and dependent relationships for traffickers. So it's really, really, really important to understand all these issues. For these young people to be placed in a placement that understands these. Nothing changes when they become 18. Their vulnerabilities remain. And I think that's a huge thing that needs to be remembered when moving on and transitioning to adulthood. Just some useful contact information on the slide. I skipped a lot because I know I'm so thank you for listening, and I'm sorry it's rushed, and obviously if anybody wants any more information I can, you know, be more detailed another time. So thank you.
That's great, Lynn. Thank you very much. I'm just checking if Debbie's still around, because I know she may have had to shoot off for a quick meeting. Debbie, you still with us?
Yes, I have about 5 minutes. Yeah.
Go for it. Go for it.
Okay. Well, thank you. Well, good afternoon, everybody. And I'm just going to have to rush through my presentation because of time shortage. But I'm from Africa, which is Africa Safeguarding Children. We are a national charity working in BME communities on modern slavery and anti-trafficking, especially in relation to children. So there are two core areas of our work in relation to child trafficking. The first is around children who have been trafficked externally from different parts of the world into the UK, so external trafficking. And most of the young people that we work with have been trafficked from African countries. So we're seeing young people from countries like Nigeria, Ethiopia, Eritrea, Sudan, and so on and so forth. Many of these young people have been trafficked for domestic slavery and sexual exploitation. Excuse me. So the key issues there in relation to how do we support these young people and how do we involve communities in prevention. So I'll come to that in a little while. The second area of work involves children in BME communities who have been trafficked internally, and the bulk of the work that we're beginning to do revolves around county lines trafficking. So I know because please I've spoken a lot about that. I don't want to go into too much details, but I want to highlight one or two key issues that are of concern to people in I guess in Black communities around county lines. So the first issue is around the impact of school exclusions and the high number of children in Black communities that are involved in that are being excluded from school, and they are ending up in non-mainstream education. For example, people referral units, and I guess this is a core issue because it doesn't seem like there's any strategy either across London or nationwide to address this key issue. And the reason why it's of a huge concern is really because people are saying that this is now PRUs, PRUs, and people referral units are being used as a conduit for child trafficking and child exploitation, where children can be recruited by county lines traffickers and then of course exploited in different ways in relation to moving drugs, selling drugs, and traveling up country. We also have a branch of our work in Manchester. So again, this is also an issue in Manchester where children have been trafficked and moved around to sell drugs. These issues are also more pronounced because of the impact of government policies with significant effect on families. So for example, a key issue that really bothers us at Africa is the issue of no recourse to public funds. When you have families where the parents are struggling with their immigration status and they're not able to work, and because they're not able to work, they cannot provide for their children. This is having a significant impact in relation to children being neglected, because children being neglected, children being abused. So there's a close link then in relation to children on child protection plans or children on child in need plans and county lines. So these are two core issues we want to highlight as well. So key issues related to the provision of prevention and early intervention services for communities are I guess some of the responses that we've had at Africa. So I just really want to very quickly just highlight some of the work we're doing at Africa. So we have a culturally appropriate service working with young people who have been trafficked. So we have a pilot project on supporting young people on supporting families where children may be at risk of county lines or other forms of internal trafficking. This is in Manchester, of course, but we're hoping that we can expand this pilot project to London. We have a referral service and psychology service for parents. So parents who might have language difficulties, they might not know where to go for help and support. They might know that their children are involved in the system, but they might not really know what to do about it for many reasons. Sometimes they might think that being involved with agencies might impact on their immigration status. So we work with those families to ensure they can get access to services that they might need. Psychotherapy support for young people who have been trafficked, especially those who have been trafficked externally, is a service that we provide at Africa. I mean, currently, of course, this is not in service because of shortages of funds, but it's a service that we're very keen to continue because of the huge role psychotherapeutic support plays in relation to young people being able to heal and recover from their experiences. The other area of our work that I really want to talk about, which is quite important as well, is the fact that we have a BME anti-slavery network, which is called Barnett. It's known as Barnett. And Barnett really is a network of grassroots organizations working on anti-trafficking and modern slavery. And the whole point of Barnett is to empower different community organizations to become more involved, either in terms of prevention or early intervention or providing services in different ways for families and communities. This is simply because of the issues we're seeing right across the board. And the idea is that we need to have community-led approaches to address many of these issues, because many of them also, have issues around culture and beliefs that influence how, the families are able to react and respond to the issues that the children are facing. And lastly, of course, is the fact that we provide training for practitioners on culture and the impact on trafficking, especially trafficking from outside the UK. Issues around us rituals, issues around the involvement of criminal gangs in external trafficking, and so on and so forth. So again, that's I guess that's an issue I really wanted to touch on. So I have to very quickly rush through my presentation. I'm very sorry for that, but I hope that's good enough for you. Thank you very much.
Brilliant. Thanks, Debbie. Very quickly, for anyone who wants to know more about Africa and Barnett, then they are really easy to find on Google. I do it all the time. I'm a proper Debbie botherer. So
you'll be stalking me.
I am. Right, Bina and Donna, I am sorry for keeping you waiting. We are running a little bit over, guys. This is the last presentation, but equally as important as all the others. So I will hand over to both of you now.
Hi, thank you very much for letting us come along. I'm hoping that presentation's come up. I'm just having a bit of a trouble. Can you see that?
We can see your screen. It's just not in presentation mode at the moment.
Right, let me just see if I can find that again. It's always when you're in a hurry, isn't it?
Yeah.
Right, let me just. Right. So just a bit of background. I'm Donna Kingsley. I'm from Croydon, from the Safeguarding Children Partnership based there. And my colleague Bina will be taking over halfway through this presentation, if I can ever get it to share. Really what we wanted to do was just to talk about it from a slightly different angle. This really kind of started from a very positive place, which was the police in Croydon really raised a challenge to the Safeguarding Children Partnership, that the number of NRM referrals didn't actually correlate with the number of young people at CAP meetings. So our CAP meetings are complex adolescence panel meetings where we discuss children who are missing, children who are suspected of being exploited. Can you actually see that presentation? It's very hard for me to see what's going on this screen.
it's still not in presentation mode. You can see it, but it's quite small.
Okay, let me just see where that.
Johnny, do you want me to see if I can share my screen? I don't know if that would help.
Does that resolve it?
Yeah, that's it, I think.
Except now it's huge. Right, okay. I'm just gonna yeah, Bina, would you mind trying to bring it up on yours? It's just not
Yeah, let me give it a go. Oh, no.
I'm gonna stop.
No, mine's not come up either. Can you see that?
If you got the slides right at the beginning.
Yeah, it's just, I think it's just a bit slow.
Great. Okay. So just go, yeah, up one slide, please. There you go. So as I say, that was where the challenge came from. And actually that was from a really positive place. The police really knew their activity around NRMs and modern slavery in Croydon, and were just not finding that coming through and correlating with some of the information that we had at the complex adolescent panel meetings and other multi-agency activity. So the collaboration, I think, is really good with us and the police at Croydon, and we actually sat down to do some work which was driven by the Safeguarding Children Partnership to start with. If we go on to the next slide, please. And what we involved really was not just the Safeguarding Children Partnership, but the Adults Board as well. Bernardo's were involved in that because we're lucky enough to have the Independent Child Trafficking Guardianship Service, which Bina will talk some more about in a minute, and the police and the local authority themselves. We kind of worked together, and what we found, which I'm sure is not unique to Croydon, but the data capture around NRMs and when they're being done was really insufficient, and there was a real lack of understanding by the partnership of the duty to notify, and a real understanding around that if the partnership was involved in a child or a case, then there was this kind of assumption that surely the police or the local authority would have already acted. Next slide, please. So the way we've approached this is really to say, you know what, whilst we appreciate that the local authority and the police generally are the first responders and would be the people that would sort of follow through on that duty of care, actually this really needs a partnership response, because otherwise there's just too many gaps. And in order to do that, you know, modern slavery is just another facet of the complex needs surrounding any young person or vulnerable person that's that somebody's already working with. And unless you know, there's so much that professionals working with children and young people already need to know, you can't just send out some guidance or expect that those duties, because they're law, will be somehow picked up and driven through. So we've decided to take but we're going to drive this by promotion of the positive outcomes and really look at case studies of Croydon young people and Croydon cases, and to try and develop a training programme that will mean that the partners really understand it from that viewpoint first and foremost. So at the moment we're in this place where we're doing this kind of collaboration around the guidance, and we're making sure that we're pulling that all together, and that the key thing I think I'm saying here is that it's supported by the Children's Safeguarding Partnership and the Adult Safeguarding Board. And what I would suggest to a lot of the people listening here today is there's an opposite number like me in every local authority that works with the Safeguarding Children Partnership, and use those as a route to driving through some of the things that you all know are the things that work and the things that should be done to support modern slavery and the NRM process. And, you know, that may be another route where you'll actually try and get some traction and some working through that. And the other thing I would say is also use that as a route to share some of these slides today. A lot of the people who'll be on this will be people who are genuinely interested, and there'll be lots of other workers who have not seen the opportunity to come to this sort of event, so that by sharing the slides through something like your children partnerships and your adult partnerships will ensure that they kind of reach those newsletters and move out there. So I'm going to leave the last few minutes for Bina to talk about some Croydon casework. Thanks very much.
Thanks, Donna. And my screen is completely frozen in the sense I actually can't see what I've got on the screen. Phil, are you able to stop sharing my screen? Oh, hello.
No, I can't stop. No, how weird. I can share my screen, Bina, which will have your presentation.
Yeah, because I can't see my slides, that's why.
Bear with me.
Thank you.
Okay, can you see that?
Yes, perfect. So, hi everyone, my name is Bina Godhanya. I'm the team manager for the Croydon ICTIG site. I'm going to try and whiz through this as quick as possible. So, as most of you will probably know by now, we sit under Section 48 of the Modern Slavery Act. And at the moment, we are only in Croydon, London Borough Authority as part of the 32 boroughs. We also cover Greater Manchester, Wales, Hampshire and the Isle of Wight, and East and Central Midlands. The next slide, please, Phil. So just to give you a brief overview of the ICTIG role, we have two separate roles that come under the umbrella of ICTIG. One of them is the independent child trafficking guardians that support all potential trafficked children who are here without a person of parental responsibility. So that's usually you as children, and we offer direct work to those young people. What we do within that direct work is it's multi-agency, it's there to safeguard young people and using a safeguarding approach. We will walk the journey through with that young person through all the different systems that they are included in, and this includes social care, it includes immigration, it includes the NRM, criminal justice system, education, health, any systems that that young person is walking through, we will work the journey with them. I just want to again highlight, as lots of people have highlighted today already, it is multi-agency. So we will at every step of the way include all the different professionals that are also working with that young person at that point. Trafficking and safeguarding is not something that any one agency can do alone. So it is about working together. If I just give a brief overview for the Regional Practice Coordinator, which is the next slide. So the Regional Practice Coordinator, we offer indirect work for young people within this role. So what came out of one of the ICTIG interim reports last year was that we're finding that young people that are in the UK with someone of parental responsibility, the ICTIG role at that point was more useful working with the professionals and providing advice and guidance to them rather than having another professional doing the direct work with young people. So across the board, we have RPCs that offer case consultation for all those professionals. Again, it's looking at safeguarding and contextual safeguarding. We also offer support in social workers, police, and other first responders doing the NRMs. We also contribute to best practice and strategy development. So we do that through raising awareness, and we offer training to different staff teams, whether it's YOS, social care, police. We are there for every agency that are there working with young people. We can offer support and guidance to. And just to give a bit of a case study, so the next slide, in the sense of how we impact and how we do get involved with all these different systems. So this was one of our direct working case studies. He was 17 at the time. It was a young Albanian boy that was referred to our service, and he'd actually been in the UK since the age of 15. So he was looked after under Section 20 and he had a social worker in Croydon. He came to our attention in, I think it was September 2019, following further concerns. So he had already been identified as a potential victim of trafficking by the Home Office when he first arrived in the UK, and an NRM had been completed at that point. Reasonable grounds decision had been made. As I said, in September, there were concerns around him being found at addresses where there were no links to. He was in possession of Class A drugs and substances. He'd also been found in different cars in completely different areas. There was a placement breakdown, missing episodes, so several indicators of exploitation when he was referred to us. The next slide, please, Phil, and potentially the next one. So we were involved with the criminal matters at that point. He was unfortunately placed in the young offenders institution as he was charged for a robbery. We remained in contact with all the different professionals with that young person at that point, particularly with the YOS worker and with the social worker. And as we know, YOS workers will do the preparation for pre-sentence reports, and it was really important for us to get the voice of the child at that point, to know that actually we also need to consider that this young person is a victim of trafficking. We also worked with the immigration matters at that point. So when he was known to us, we found out that he actually had no current legal rep regarding his immigration. He previously had, but because he'd been moved placements, there was no current legal rep that was holding his case, which was a real concern. The ICTIG at that point contacted lots of different firms, and we were able to find a firm that was able to take and represent him, and they were a really good firm. Actually, they had a lot of knowledge around trafficking. The NRM, he had received a conclusive grounds decision based on the trafficking that he had experienced in Albania and in Europe, but the decision that had been made, the actual decision letter had said that they had not recognised him as a victim of trafficking within the UK. The ICTIG at this point, when he was referred to us, had kept updating the SCA with all the information about the current concerns that we had. And at that point, when the conclusive grounds decision was made, even though it was an overall positive, the negative had been made in regards of internal. So at that point, the ICTIG reflected on all the information, and we felt that that was not the correct decision based on the information we had. We'd asked for it to be reconsidered, and there is a process for that to be reconsidered. It has to be within 3 months of conclusive grounds decision to be made, etc. It was reconsidered, and he did receive a positive conclusive grounds for both external and internal trafficking on the basis of CCE. One of the final slides is the ICTIGs. We also get involved around the welfare of the young person. So we worked really well in partnership with social care and the social workers. He had a change of social workers, and obviously, you know, that's really, it can be very disturbing for some young people having to get to know and trust another professional. We were able to bridge that gap a little bit and introduce the new social worker, and it just helped to keep that relationship going. All leaflets and information that the young person was receiving throughout this time of the ICTIG intervention, we were able to go through with them with either an interpreter or have the documents translated, which again is really useful for young people because they really don't understand these systems that they're in. And initially when you explain it to them, they may say yes, yes, yes. And then you kind of find a little while later when you ask them to feed back what they think is happening to them, they don't have a clue. So important to keep those conversations going about what's happening with them so they can understand the different systems. And that literally was a very quick shop stop as to what we do. My contact details are there if anybody does want any more details around our service. We do offer a 24-hour, 7 days a week support line, and we do offer immediate response at that point, the immediate safety guidance and welfare checks that we will do if those young people are under one of our local authorities. For example, if it falls under the weekend, we will have that communication with foster carers over the weekend. So just so you know that we have got the support line for professionals as well.
Wow, well done. So that brings us to the end. Tamara, I don't know, I appreciate we are well and truly over time, but I didn't know if there were any pressing questions from any of the delegates. So what I'll do is we'll leave it there then. We'll make sure we put the information out. Certainly from my perspective, I mean, it's just been a really, really interesting day, despite the fact, as I'd already said, I'm a self-declared modern slavery nerd. That is, there's been some absolutely brilliant presentations. What I will, just one thing that I've just wanted to say already, for me, the main message is just be bold in terms of your collaboration. You know, this is such a complex matter that actually, you know, together we can really make a difference. And I'll hand over to Tamara for her last thoughts.
Yeah, no, just it has been absolutely packed day, and I'm sorry that we weren't able to keep to time, but I think a lot of you wanted to hear those people who were speaking, so we tried not to cut people off as much as possible. But I know some people are concerned about some of the slides being shared. I understand that all slides will be shared as well as videos, and obviously the contact details of the speakers are on a lot of the slides. So if you want to get in touch with individual organisations, you should be able to do so when we send out that information. Thank you to all our amazing speakers as well. They've been absolutely fabulous, and we are very, very lucky to have had such a great lot of speakers today. And thank you again to Rachel, who has organised this entire event and been absolutely amazing. And we're very sorry that she's leaving us very soon, but thank you so much, Rachel, for all your brilliant work. And thank you to all the people who've attended, because I know council work, you have a huge amount on, and especially with COVID, so I really appreciate that you've managed to take a big part of your day to actually learn more about modern slavery. So thank you, everybody.
Thank you.
Cheers. Bye, everybody.
Bye.
Someone's asked if my gas is fixed, and they're still drilling away. I don't know if you can hear in the background. So we should have heating by the end of the day, fingers crossed. But thank you very much to the audience member, Trevor. Thank you for your concern.
Tamara, I'm going to jump off. If you wanted, I'm free until 3 o'clock. If you wanted a quick catch up on Zoom.
Yeah, yeah, on Zoom. That's good. Again,
yeah, right. I'll see you in a bit.